Good morning. My name is Yvette McVeigh. I'm a benefits counselor with the Area Agency on Aging. Welcome to the estate planning for older adults. We are sponsoring this outreach with the Texas Legal Service Center along with Mr. Paul Zambie. And I think we are ready. Mr. Paul?
Okay. Well, thank you everybody for showing up today. As Yvette mentioned, I'm an attorney with Texas Legal Services Center. We are a legal aid out of Austin. We do handle and cover cases around the entire state, but today we're assisting the area agency with an estate planning clinic. And I'm going to describe to you today several documents. It's going to be kind of a buffet of things that you can avail yourself of. And these are free. I mean, the area agency is putting this on. We have other attorneys involved, and some are doing these, some are doing those. But again, it's great information today. It's free legal services to prepare these estate planning forms, and it'll be information about other forms. But also, if you can't yourself or avail yourself of these, or you don't need them, maybe there's somebody you know, maybe it's a neighbor, maybe it's an elderly person or something like that. Let them know about these services. This is open to all. So spread the word, okay? So today we are going to be talking about several things. The first thing is going to be the transfer on death deed. And in a nutshell, you need to think of this just like a will for your home. And it's better than a will for a couple different reasons. But the way that it's like a will is that it's something that you do now when you're still alive, while you're still competent. It does not spring into effect until you pass away, just like a will. It's better than a will for a couple different reasons. One is that it avoids probate. And for any of you in the audience who have gone through probate, you know it's not fun, it's not quick, and it's not cheap. Things can drag on, things happen. It may be a couple $1,000s at a minimum to do these things. If you can do certain things to avoid probate, and I'm going to kind of tell you later on how simple estates can avoid probate, then that's the name of the game. Even if you have a will, you may never need to use it because you've done some other things to avoid probate. So it avoids probate. The other thing is that it avoids Medicaid estate recovery, and I'll be talking about that in just a minute. If you have done any estate planning in the past, you may not have heard about the transfer on death deed because it's fairly new. It's within the past 5 years. A lot of people have done their stuff before, and you may have heard of something called a ladybird deed or set up a trust or something like that. This transfer on death deed is something that's been replacing that for the past 5 or 6 years. It does have a statute behind it. It's in Chapter 114 of the Estates Code, and it's fairly widely accepted. Our Texas form is just for Texas properties. It can't be used in any other state. But having said that, now over half of the states do recognize a transfer on death deed, or some call it a beneficiary deed. And again, it is an excellent way of transferring your property. So the reason that our legislature did this is that we have a pretty big problem in Texas, and you can call it several things. I'll call it clouded title. And that's where somebody owns property, but they die without a will. Where does that property go? You may have in your mind that you want it to go to this one person, this nephew or niece who's great, or maybe a son and daughter who's been in your home helping you in your later years. And even though you have 10 kids, you want it to go to this one person. Well, what do you think that oral promise is worth in today's world? I mean, absolutely nothing. If you pass away without a will, the laws of Texas determine who gets the property. And it's not, oh, that's a good guy and that's a bad guy. No, it's a class of people. It could be a spouse. It could be all of your children. If you don't have those, it could go to your brothers and sisters. If they pass away, their share goes down to their kids. So you can see that things can get messy pretty quick. In a couple generations, if someone dies without a will, their real property, and their kids who kind of inherit it because there was nothing specific, but they do it through the laws of Texas. If they don't have a will, because they did what mom and dad did, they didn't have a will, and they pass away, you know, you can have a dozen or more people, you know, have a share of this property in just a couple generations. And again, it can get very, very, very messy very quickly. And the problem is, let's say that you have that one person you want it to go to, but because you didn't have a will, it goes to your 3 kids. And let's say that your 3 kids get along, that's great. But what if they don't? Well, one of them may want to keep the property, one may want to sell the property, one may want to rent it out. And if they can't agree on what happens to that property, it's not going to get done. They're all owners, rightful owners, and they all have to agree on what gets done with that property. So we have seen fights occur, you know, disagreements. One gets angry, one, they don't pay their share of the taxes, the mortgage, their upkeep, whatever it is, and that burden shifts on to the others. And those others may be unable or unwilling to cover those costs. So things just don't get paid then. And we've actually seen homes go into foreclosure, and it results in abandonment. They lose their property because people aren't doing their fair share. So you want to have control. The whole point of today is to having control about your later years and what happens after you pass away. And this is one of those things. So the benefits of a transfer on death deed. First of all, if you go to an attorney for a will, he may charge you several $100s, okay? Well, today we're doing this for free. This is the transfer on death deed, so it can save you hundreds then. As I talked about, when you leave it to your kids or whoever you leave it to, it can save them thousands of dollars by not having to go through probate. But the much bigger, potentially bigger benefit is that it can save tens of thousands or hundreds of thousands of dollars if it saves your home. And what I'm talking about there is there's this thing, Medicaid estate recovery, and it's when those good folks from DADS and HHSC come out and they see if you're eligible for certain services. And if you are, they'll say, great, you get these services all throughout your lifetime. But if you pass away, we get to take anything out of your estate to pay us back. Okay, so this can actually protect the property from that. And it can actually negate the need for a will in a lot of instances, especially for my clients who don't have a whole lot. We deal with the lower income folks. You know, if they have complicated, you know, businesses or trusts or something like that, and you need to give to your property to people in different proportions, well then, yes, you may need a will and trusts and another, you know, group of documents. But for my folks with simple estates, you don't even need a will. So I hate to be that, you know, in all throughout your life, you've probably gone to seminars, you gotta have a will, gotta have a will, gotta have a will that's been kind of pounded into you. I'm kind of that attorney in Austin who's saying at times you don't need a will because of the costs on the ends of it, on the front end and on the back end. So on Medicaid estate recovery, as I was talking about, again, that's when DADS comes out. It's normally to do with somebody having to go into a nursing home or somebody trying to stay out of a nursing home because they're getting a provider in home. Okay, both of those are considered long-term Medicaid. And when you are signing up with them, the caseworker comes out and they actually want you to sign something. And it's Form 8001. And it's kind of a scary form. It's something where it talks about when you're qualified to get on services, what your exemptions are to avoid Medicaid estate recovery and the government taking it. But it's something that you have to sign. A lot of people think that because they're signing that, they're giving their home away right then and right there. And that's not the case. Those caseworkers have to go back to their supervisor and they'll say, hey, we signed up Miss Jones today for services. And the supervisor says, okay, well, you know, by law, you had to have told them that there's a chance they can lose their home to our recovery unit. Did you get them to sign Form 8001? So they have to have the people sign these. But because you're signing something, the elderly get so scared, sometimes they'll just get up and they'll walk out and they'll say, look, you know, I need these services, but if you're going to take away the only thing that I've worked for my whole life to leave to my kids, even if it's a modest $50,000 or $60,000 home, they walk out. We get that call all the time. If you ever hear of people doing that, there's a solution for that now. It's the transfer on death deed, okay? They can get all the services they need from long-term Medicaid, and yet they have the peace of mind that they're not going to lose their home because they have the transfer on death deed in place. So when somebody passes away, Medicaid has the right to get anything that has passed through their estate. Okay, that's the important term. So the name of the game is to not go through probate, not have things pass through your estate. You want things to pass through or around your estate. And the transfer and death deed does that. It does not require a lawyer. It does not require a probate action in front of a judge. With a will and probate, again, it may be a couple $1,000s, and after several months, judge signs off on everything, the executor or the administrator disperses the property, and then it's done. But again, that's thousands of dollars in several months. With the transfer and death deed, when somebody passes away, whoever's getting the property has to wait 1 week. They have to file something for about $50 and it's over, okay? Title to the home is done and you don't have to go through any sort of probate. But again, it's really, really sad when you have people walking out the door, and you have to watch out for that. So just real quick, the way that you can avoid probate is that everybody here has 3 groups of stuff with title to it, and that's your home, your car, and then your bank accounts. So with the home, if you do a transfer and death deed, it's going to go outside of probate, and so Medicaid can't get to it. Notwithstanding the fact that you're also avoiding the cost of probate. There is a similar document for a vehicle, and on your bank accounts, as long as you talk to your financial institution for free, they can name a beneficiary on there who gets it upon death. It's called a payable on death beneficiary. It's free to do. You just go to your Chase Bank or whoever you have your checking and savings with, or Fidelity if you have your stocks or money markets through there, whatever it is. And as long as you name somebody on there, that passes outside of the court system. So if you do the transfer on death deed for the home, a transfer on death deed for the vehicle, and you do that payable on death designation for your bank accounts, you can avoid probate. And again, for my folks with simple estates, they can do that. And it's very, very important. So in general, who qualifies for the transfer on death deed? I mean, today we said that all the services are free if you sign up, but in general, let's say you weren't even attending this, the transfer on death deed is for any property owner in Texas. It applies to real property, which is your land and anything that is attached to the land. So if a home is built on the land, that qualifies. If there's a barn on there, if there's a windmill, whatever it is, if it's on the land, it's going to transfer with a transfer on death deed. It is not for personal property, which is homes, which is, cars, money, jewelry, clothing, guns, things of that sort. Those things you'll have to do other things for. But still, at least with my clients, their home is, 95% of their total assets. So it's the most important thing in their life, and this will do it for them. So it's any property owner in Texas, and it's any age or any income level. So you don't have to be necessarily old. You can do this at age 24 if you own a home, whatever it is. And you don't have to be poor to do this. I mean, you can be well-to-do, any age or any income level. When we talk normally about when we can help people outside of this clinic, yes, we help low-income folks. We're a legal aid. This clinic, our services are different. We can do it for everybody in this clinic. But let's say that you weren't even attending this. This law is for everybody in Texas, no matter what age or no matter what income level. In a little bit, we're going to be talking about the durable power of attorney. And that's a wonderful document. It can help with a lot of things. You can do financial things with it, real estate things with it. And normally you can do a lot of things with, deeds and homes and real estate. You specifically cannot use that with a transfer and death deed. The legislature was worried about people abusing that to get somebody's home. So they wrote this law specifically stating that it's great to have a durable power of attorney. You can do it for a lot of other things, but it cannot be used to assist somebody in getting a transfer and death deed. And the good thing about the transfer and death deed, which is different from this thing that I talked about called a ladybird deed, which is what has been available in the past, is that you can name multiple or alternate beneficiaries on it. So you can name one person that you want to get the home. If you have 3 kids, you can name 3 kids to get your home, no matter how many it is. You can name one person, and if that one person dies, you can name a number 2, somebody who would get it in case that first person dies. So the form actually has a lot of leeway with it. And the requirements, fairly simple. The form gets filled out properly, of course. It has to be notarized by the owner of the property, and then they have to file it down at the county clerk's office where the property is located. And it has to be done before death. Now, when I've said that we're doing this for free today, if you want to sign up for it, that's the legal work. We will not be paying for filing fees. I believe they're going to have a notary available, if I'm correct, maybe to notarize these if you need that. But if not, a lot of times you can just go to your bank and you can do that for free. Filing fees around the state are usually less than $50 per document. Again, we won't be covering those fees, if my understanding is correct, but I believe they might have a notary available. What is the effect of a transfer and death deed when you fill it out, you get it notarized, and you file it? It's zero effect right now. It's a transfer on death deed, and you haven't passed away. So even though this is filed, even though you've named beneficiaries to get it, you retain all the ownership rights and responsibilities. So if you want to sell the home, that's fine. You don't have to get anybody's permission. You want to get a mortgage, same thing. It's just you that has to sign that. By the same token, just because you've named somebody to get this when you pass away, they are not on the hook to pay taxes for you, insurance, mortgage, upkeep on the property. That's all yours while you're alive. So again, zero interest in the property is transferred while you're still alive. So you're saying, Paul, I already have a will. Why would I want one of these? Well, again, we already talked about the cost savings of that. And a big thing is that it avoids probate and it avoids Medicaid estate recovery. Even if you have a will that names somebody to get the property, Medicaid gets the property before your wishes in the will. So Todd trumps Medicaid, Medicaid would trump a will in this instance. What if you have both? What if you did a will several years ago and now we help you with the Todd? And what if years ago you named little Johnny to get your house? But things have changed. Johnny may have passed away. Johnny may have won the lottery. He doesn't need it. Johnny may be estranged, whatever. Now you want to leave it to Susie. Well, in the transfer and death deed, if you name Susie, that's going to trump whatever you have in a valid will. Okay, so your provisions in a Todd are going to trump those in a will. And a lot of people will ask, well, do I need to revoke the will then? No, you can just let it sit there. Again, even people with a valid will sometimes don't get it probated. And by the way, that's another problem. This false sense of security that people have. Let's say dad dies without a will. We've already talked about that. Let's say that they do have a will. You don't know how many times I've got that call where somebody has never probated the will. And if you don't probate the will in 4 years, it's like it was never written. It's no longer good anymore. So you have 7 kids, but that one child helped you and you want it to go to them. You even name them in a will. But if you don't probate that will after 4 years, it doesn't go to that one child. It's going to go to your 7 kids. So people are lulled in this false sense of security. Oh, a will was done. That's the only thing I have to do. No, you have to go down and probate it. And another thing they do is when somebody passes away, either with or without a will, a lot of people don't probate it. What they'll do is they'll take a death certificate and they'll go down to the tax office where you pay your annual property taxes, and they'll submit that, and the county tax assessor there will say, thank you very much. We're going to put your name on this. You get to pay all the taxes now. We won't foreclose on you. Right then and there, those people think, wow, I own the property now. I've changed title to it. They haven't done anything of the sort. All they're doing is they'll pay the taxes, and that tax man will take money from them, me, or an old brown shoe. I mean, as long as they get their money, they're happy. That has nothing to do with ownership of the property. That's done in the deed records at the county clerk's office. So you've got these people thinking they've done something. I've had them call me, yeah, we did that 15 years ago. They didn't do anything except stop foreclosure for non-payment of taxes. So I get that call, Paul, my gosh, I mean, you know, a will, I know I can change a will, this or that, but you're telling me I have to get this notarized and then file it down at the county clerk's office? Man, that sounds so permanent. I don't know if I want to commit to that. Don't worry, this is a revocable transfer and death deed, okay? There's an actual just cancellation form. If you file a new transfer and debt deed, it's going to knock out the old one. If you sell the property, like I said, you have the right to do. That pretty much revokes it, because when you die, they see this paper passing this property to somebody, but if the individual didn't own the property at the time of their death, it's just null and void. So, and also if you get divorced and you had named your spouse as the primary person to get this, that divorce can take that person off of there, and then it'll go down to their beneficiaries. Yvette and Alice, I'm going to be continuing with the rest of that, but are there any questions now? We can open it up on the transfer and death deed.
Yes, hi, Paul. There are two questions. Does the Todd apply to commercial property or only personal real estate property?
The Todd applies to any property, whether it be commercial or personal property. So as long as it's real property. And one thing about that I forgot to mention is that, you know, we'll sign people up and they otherwise qualify and they've got this land and they've got this deed, everything's fine. A couple questions later, we say, I find out that their home on the property is a mobile home or manufactured home. 95% of the times when you buy one of those are categorized as personal property that will not transfer with a transfer and debt deed. They treat it more like a car or something you can move away. So the Todd is only good for the land in that case. The game's not over. There's this Texas department called the Texas Department of Housing and Community Affairs, where you can actually change the legal designation of that mobile home or manufactured home to real property. And it's not very, I think it's less than $100. It takes maybe a couple weeks or a couple months. But then once that's designated as real property, that will transfer with the transfer and debt deed. But yes, personal, you know, your home or a commercial property, the Todd will be good for both.
Okay, what's the difference between the Todd and the Lady Bird Act?
Todd and the Lady Bird deed has been around for maybe 35 years or something like that. But it was literally just invented by an attorney. And he said, I like that. I like that. I think I'll put that in there. And it's a real thing in Texas. I mean, Texas accepts it. Not many other states do. It's only accepted in about, I think it's 5 to 7 states or something like that, where the transfer and debt deed is more widely accepted. In a nutshell, though, the Lady Bird deed gives your property away right now. And then when you pass, and all you retain is the right to live there until you pass away. Whereas the transfer and death deed, you're retaining all of it now, and it doesn't pass until you pass away. They both accomplish the same thing. They both avoid probate, and they both protect from Medicaid estate recovery. If we have somebody come into our office and they have a Lady Bird deed, I say, you don't need a transfer and debt deed. You paid good money for that, you're good to go. If they come into us with nothing, then we say the transfer and debt deed is the way to go. The ladybird deed can be costly. When the transfer and death deed law was passed, the legislature actually had forms in the statute. So an attorney didn't have to prepare or invent their own form. They just used the one that was given to them. With the ladybird deed, because there's no statute, they're kind of writing up their own form. So they consider that their work product. And attorneys can charge, commonly $500 to $1,000 for a ladybird deed. Whereas the transfer and death deed, again, it should be a lot cheaper because of the forms. But those are the general differences in the ladybird deed and the Todd.
Okay, I have 2 more questions.
Mhm.
Will a copy of this presentation be available to participants after today?
Yes, I believe if you contact the area agency, I believe they can make a copy of it available. And I believe it's going to be recorded and then may even be posted somewhere. We'll have to ask a vet and Alice about that.
I have 1 more question. Okay, you said a will has to be probated within 4 years. That is after the individual dies, correct?
Correct. Yes, it's not 4 years after it's written. It has to be probated 4 years after somebody's passed away.
Okay, that's all the questions we have for now.
Okay, and by the way, this is such a small group. I'm going to be stopping after a couple things. If anybody has any questions about what I've just gone over, or they think of something on the time in the past, just let me know. Okay. Continuing on. All right. Well, Paul, you've told me I need this. You said it's bad to die without a will. You have to have all this planning done. Well, that's great. But in my situation, my dad died 10, 15 years ago. He didn't have it. We're living in the home because we've been paying the taxes, but now you've told me I'm not on the deed. What do we do? So there's 2 basic ways of getting that done. One is an expensive way, and it's fairly quick. It's where you hire an attorney. He goes in front of a judge, and the judge determines who the heirs are, and then the judge decides per the laws of Texas who gets the property. And that probably can be done within a 6-month period, okay? A matter of months, but it could be a couple $1,000s. My clients really can't afford that, so the next best thing for them is called the Affidavit of Heirship. This is something where you're naming the same proof, you're determining who the heirs are, who the spouses, the kids, the brothers and sisters, nieces, nephews, stuff like that. But instead of going in front of a judge, it's a form that gets filled out and it just gets filed at the county clerk's office for less than $50. So it's cheaper. The problem is it's not quicker. Mortgage companies and title companies, if they want to, they can say that has to be on file for 5 years uncontested. Nobody else can file an opposing one, 5 years until we take notice of it. Now, in the real world, I've seen them accept it a lot quicker than that. If somebody wants the money, they just want to know that something's on file. The form has to be filled out by the family from the deceased perspective, as if he was filling it out. The problem is nobody in the family can sign it. It has to be signed by a disinterested third party. So I tell people, look for a family friend, a neighbor, a church member, something that who knew your parent that passed away. You fill it out, you show it to them, they get their signature notarized, they give it back to you, and then you file it down at the county clerk's office. It's the same place that you would file the transfer and death deed. It's the county clerk's office, the deed records, okay? And again, this is just something that will slowly transfer property to somebody else without the need for probate. So a lot of people actually choose this. I've had clients who've just said, Paul, I know probate's the best way to go, and it's the thing to do. We have a will here. I just can't afford, our families, living on, we paycheck to paycheck. We can't spend that $2,000. If everything is clear as far as ownership, some of them actually don't even probate the will, and they'll just do one of these. It's not exactly as good, but it's the next best thing. Now, this is something where we will not be filling out for people, but we will give them the form and we will give them kind of guidance on how to fill it out. So transfer and debt deed, you can sign up, we put pen to paper, we fill that out for you. This we do not. We'll give you a form, guide you with it. It's not part of this clinic. Let's switch over to Miller trusts. This is also called qualified income trust. I talk about the prior example where somebody is a caseworker from Dad's Health and Human Services has gone out to see if you're eligible. What I meant by that is they look at your assets and your income to see if you're low income enough to qualify for their services. And right now, if you're an individual, you can have income of almost $2,400, okay? So a lot of people, their Social Security checks are well under that, but some people do have more than that. So let's say in an example here, they have $2,500. And I tell you, Health and Human Services doesn't say, you're a couple dollars over, we'll still put you in. Boy, if you're a dollar over, you will get denied, okay? So let's say that you have, instead of $2,382 income a year, you have $2,400. You're $18 away, you've been denied these services just because of that $18. What do? There's an answer for that. It's called the QIT, Qualified Income Trust, and you can actually put all of your income and pass it through this trust, and what comes out of it, you can pay some personal needs, you can pay the rest to a nursing home, whatever it is, but you will still qualify for the services because let's see if this math is correct here. Let's say that if you have that $2,400 a month, well, that comes out to $79 a day, okay? So that's what you would have to spend on your care, whether it be a provider in home, a nursing home, whatever it is. Well, shoot, the next line there, and these figures, they may be old, it's at least $167 a day for private care, whether that be in a home, provider in home, whatever it is. So, you know, Paul, I'm getting $79 a day on average, but I have to spend $167. The math doesn't add up. I can't afford to do this. So that's why you can pass your income, even if it's over that amount, and you can funnel it through and you will still qualify for Medicaid. Again, the folks listening to this may not affect you, but it may affect your parent, it may affect a neighbor, something like that. If people have been disqualified from getting Medicaid services because they've got too much income, there can be an answer for that, okay? And this is something that we can be filling out for you. So you contact the area agency, fill out the proper intakes. This is something we can put pen to paper for you. It does cover just income, okay? Assets is a whole nother thing. If you have 2 houses, if you have, you know, $20,000, whatever it is, you're going to be disqualified for that. And there may be other ways of spending that down and getting around that. We talk about trusts, you're putting stuff in there, meaning your money that you have, savings and stuff. Savings does not go into this. You're not allowed to put that in here. It is just for your income, not your assets. A couple other things about this. The QIT has to be irrevocable. You can't change it. A lot of people don't have somebody they trust to be the trustee, and they put themselves, or they might even put like the nursing home director or something like that. Those are both bad ideas. You should have somebody do it besides yourself in case your mental competency goes down. What if you move to another nursing home or that director leaves? Well, they're named on this thing and they want nothing to do with your QIT anymore. So you should name a trusted family member. But again, what gets paid out of this? Money for the spouse, medical assistance for your own medical bills. It can be very useful. Again, you should not mix other funds in these accounts, or it can be counted as a resource and then you can be denied. So again, only certain things go in here. You don't want to put any assets or anything in there. It may blow it out. I'm on to powers of attorney now. And remember, if anybody has a question, they can just ask Alice or Yvette, and they can interrupt me after a slide or something. Powers of attorney are extremely important. These are for use when you're still alive, okay? Because all powers of attorney die when you die. So again, it's not for planning after you pass away, estate planning, it's when you're still alive. And the huge importance of these is that this can avoid guardianship. And guardianship is the dirty 4-letter word of estate planning. It's the last thing you want to do. If you're subject to a guardianship and a judge awards somebody as your guardian and you're now a ward of the state and of them, you cease to become a legal person. I mean, you're still alive, but you don't make decisions for yourself. If somebody says you've got to get that medical treatment, you're going to go in that home, this is what you're going to do, you're going to listen to your guardian. So these things are things that are a step below guardianship. You still retain a lot of your rights and decision making. There are two main ones, or only ones really, a medical and a financial. If you have both, you've kind of covered all bases. The general requirements, these things have to be in writing. You have to name the person that's going to be your agent. You have to say how the power of attorney is going to be used. And on the forms that we use, they have certain things that are already written out. You don't have to think and reinvent the wheel. I kind of cringe when I hear people say, oh, I wrote out my own will, or I wrote out my own power of attorney. Don't do that. There's forms out there that can be done for that. There's definitely forms for the powers of attorney that we use. Just go by what they do. Don't try and reinvent the wheel. All of these have to be notarized. Even the medical power of attorney can also be witnessed. But if you just want notary, that's fine. You have to be of 18 and sound mind to do these. You can name agents, co-agents, and alternates in some instances. So you have to pick a trusted person. Again, this person can have a lot of power over you. So you want to kind of almost interview these folks, know it's somebody you trust, make sure that they're willing to do it, because if they have no interest in this, you've named somebody who's not going to do a good job. A big thing, and again, this is a step down from guardianship, is that even if you give somebody power of attorney and they're your agent under that, yes, they can act and do a lot of things, but if you disagree with them, your word is going to trump their power of attorney. So if you're both at the bank and your agent says, I want to take all of mom's money out of there and I want to put it in this other account. Well, if mom's sitting right there, and if she's mentally competent, she can say, no, I don't want that to happen. The guy says, I've got power of attorney. No, the words are going to trump the power of attorney. And that, again, that's one of the big protections for them. If you have to go that next step to guardianship, your word does not trump the guardianship. So just watch out for that.
Paul,
Yes.
we have a question.
Okay, sure.
Okay, are there new requirements which require the two disinterested third-party affirmants to attest to the value of the estate of the deceased party?
Are there new requirements for that?
Yes.
I'm going to be honest, I have not heard about new requirements for that. On the power of, on the Affidavit of Airship, I know it's usually used for real property and not money and other things. So it's good for your home and your land, and that's why you need a property description on there. I can't imagine, I will look it up after this. I can't imagine there'd be a requirement for this, because that would require a certain level of expertise and training for a lay person, just some ordinary witness, to attest to the value of a property. So I would kind of say no, but if somebody has heard something, I can definitely do more research and look it up. Initially, I would say probably not.
Okay, thank you.
All right, on your medical power of attorney, what does it cover? It covers everything that your financial person does not cover. Your agent who you give power to can consent, refuse to consent, or withdraw consent to any treatment. The medical power of attorney lists on there where the original is kept and who might have copies of this. So that's a very valuable thing on the form. When you fill one out, the statutory form revokes all prior powers of attorney. So that's good. And it does exist indefinitely until it's revoked. A big thing is it's not supposed to spring into effect until a doctor says that you're no longer competent. I'm going to be honest, in the real world, I think, a lot of times these are accepted by people without a doctor having to do that. But I think per the letter of the law, medical power of attorney is supposed to just spring into effect when a doctor says so. There are some protections on the form because, again, maybe you don't have that trusted family member to do that. You need to interview people. So you'll say, well, maybe I can have my health provider do it or my resident care provider. That's a bad idea. Those people may not have your best interest in mind. They may want to keep you in their facility to get more money, and they make the wrong decisions for you. So you're not supposed to appoint your healthcare provider or resident care provider on that. Financial power of attorney, just the opposite. It covers everything that the medical does not. It's all of one's personal financial affairs. You can transfer title, open and close bank accounts, provide money for your family, pay bills, make investment decisions, pay taxes, open up CDs. The big thing about the power of attorney, the financial one, is that it has to be called a durable power of attorney. So I'm sure there are forms out there right now where it can give an agent all the rights that I just mentioned, but if it doesn't have this special language about durable, then that power of attorney, the general power of attorney, dies when the person becomes incompetent. Okay, so it has to be a durable power of attorney, and that's the one that survives incompetency. And that's what you're doing this for. I mean, yeah, you can give somebody a power of attorney. If you're fine to make decisions on your own, why do you need that thing? You're doing this in advance for when you're not competent anymore. So you want to have the durable one. And this is the danger of getting a power of attorney from just anywhere online, or like the forms from Home Depot or Office Depot or something like that. I get those calls all the time. Is that a good form? I say, you never know. I mean, a form in Delaware might be a great general power of attorney, but is it a durable power of attorney where it survives somebody's incompetency? So you don't know. You want to use the Texas form. On both of these, we use the statutory forms, and in this clinic, these are two documents that we will put pen to paper. We will prepare both the financial and the medical power of attorney. Okay. And again, there are guards on the form where you can limit it to specific activities or situations, periods of time, whatever it is. You can choose that it takes effect immediately or only when you're incapacitated. Real quickly, this slide is just that there are certain things that you cannot do with it. If somebody has power of attorney, they can't vote for you. They cannot create a will on your behalf, just like they cannot create a transfer on death deed. And if you happen to be guardianship of another person, just because you give someone power of attorney doesn't mean that they are now guardianship over that third person. Only the courts decide that. So that's like one of the lessons. Guardianship is the top level. You lose everything, and a judge has say over everything. So even if you have some powers of attorney in place, if now there's a guardianship, a judge can say those powers of attorney are worthless. My word and the words of this court and your guardian now rule over those powers of attorney. So that's why it's important. These powers of attorney can be a great thing as a defense to guardianship.
Paul?
Yes.
We have a question. With a general doable POA, what about self-serving? Can an agent named in a POA sign a deed transferring ownership of real property to themselves?
Yeah, sometimes you can do that with a power of attorney. But yeah, you can do deed things with that, and that's why it's so important, and they can be kind of dangerous. So if somebody has done something wrong and done that when it's self-serving, you may have to get the authorities or APS involved. but that's why the legislature specifically wrote that you cannot do a transfer on death deed with that, and you can't do a will. But yes, during your life, sometimes you can use that to give it to yourself or one of your buddies or something like that. So yeah, that can be a problem. Yes. So the answer is yes, that can be done, and that's a problem sometimes. Okay. One of the other forms that we're going to do is a living will. So when we talked about the medical power of attorney, there's going to be 3 different kind of medical advance directives that we do. The medical power of attorney, the directive to physicians, which is also called the living will, and then the do not resuscitate, which we're going to go over in a minute. We will do all 3 of these documents for you. Medical power of attorney is kind of that first level. It's just kind of where do you get the medical treatment, what kind of medical treatment, this and that. The directive to physicians is kind of a step up. So the main purpose of this is for somebody to inform a physician whether they want life-sustaining procedures performed on them if they have an irreversible or a terminal condition. Well, what are those? Irreversible condition is something that you can be treated for, but it can never be cured. A terminal condition is one where a doctor says you probably don't have yet about 6 months to live. So again, if you have those 2 things, that's what the directive to physicians will cover, okay? And it's called the living will. I don't really like that name because when you think of a will, you think of stuff that gets transferred. This is more of a medical thing. It can be done if you're not competent, if you're a minor. Sometimes you're past beyond that stage, and you can have your guardian, your agent, families, and doctors prepare this document for you. You have to inform your doctor, and the doctor has to make it part of his records. It can be revoked, just like both powers of attorney can be revoked. If you don't like the person, this thing can be revoked. If a doctor performs under this, so they withhold medical treatment from somebody because they had one of these things, and the person dies because of this, that doctor is not considered, he hasn't run afoul of the law. He can't be accused of mercy killing or aiding suicide or something like that. So again, that's a protection for the doctor. The next step up, so you had the medical power of attorney, just general things, the directive to physicians, which is for irreversible or terminal conditions. Then you have the next step. This is it's called the DNR, the out of hospital do not resuscitate. This is something where you can fill out a form to say, hey, doctor, or hey, EMS person, or hey, person who comes to my home to treat me, don't revive me, or don't save me. Because sometimes, and this is a hard conversation you need to have with your family, sometimes the cure or the condition that you'll be in alive may be worse than if you had passed away in your own mind. You may not say, I don't want to live like that, or I don't want to be in a coma on life support, something like that. So this is that step above. And this comes into play when you are having respiratory arrest or cardiac arrest. Respiratory arrest deals with your breathing and your lungs. And it's not that you're having difficulty breathing, is that you've stopped breathing, okay? Arrest means stop breathing. Same with cardiac, that deals with the heart. Your heart's not having trouble pumping, your heart has stopped beating, okay? So this is for that next level when you're stopped breathing or your heart has stopped. This is so important that this is the only form that has to be assisted completed with a doctor. So while we can give you this form, a doctor has to do part of this form as well. And again, it's for healthcare professionals or EMS workers to withhold that treatment. So if you want the treatment, you don't need one of these. This is done when you withhold it. And it covers things like CPR. Do you want them to do CPR? A tracheotomy, where they put a tube in here. Defibrillation, that's where they get those things that they say, hold, shock, and kind of gives you an electric current in there. It is good for when you are in a private home. ambulance, ER departments, doctor's offices, and long-term care facilities, nursing homes. So it's not in a hospital, it's anything but a hospital. And your question might be, well, shoot, this ambulance workers come to my house. How does he know if I have one of these things in writing? I mean, I guess you could always keep one in writing there, but is an EMS person going to read that? And in the time he reads it, is it going to be too late anyway? So a lot of times you can have a badge or a bracelet that you can order for these that you can wear. A lot of times, if you're in a nursing home or if you're at home, you may be well known to these care providers that, we have to go over again on Miss Jones. This is the third time this month in her home, so they might know about it. But yeah, it can be an issue actually getting somebody, to know about that. We talked about guardianship, how that's that dirty 4-letter word. This is the thing that you want to avoid. There is a great form called the designation of guardianship before need arises. And in a nutshell, what this does is it permits you, while you're still alive, to name somebody that you trust to be your guardian if that situation ever arises. So just by signing this, you're not creating a guardianship. It's only later on in life when someone hires an attorney, they go in front of the judge and says, I want to be guardianship over that person. So whoever you name in here, odds are the judge is going to name that person as your guardian, again, if a proceeding has been instituted, unless the judge knows that that person is a bad actor and it's not in your best interest. Generally, he's going to do it. I think the bigger reason that people use this form is that in the form, you can actually name who you do not want to be your guardian. So, boy, I've got that daughter or my nephew, he's the only family I have left. He's after my money. He's going to do bad things to me. So you can actually name in there who you don't want to be a guardian. And there, a judge doesn't get to decide. A judge cannot appoint that person who you've excluded to be your guardian. In general, on the advanced directives, we're almost at the end here. A lot of people move in from other states and they'll say, Paul, I have these advanced directives, my living will from Florida. Do I really need one here? So technically, Texas will recognize other jurisdictions and other states' advanced directives, and many states will, but not all, many states will accept ours. The problem is, what if they don't have specific language that Texas uses? Or in the case of that power of attorney, what if they have the general power of attorney, but it's not durable? So I just always say, yes, technically we will accept that, but it's always good when you move to a new state, do the new ones here. And again, we can do these for you, or maybe you're here on behalf of somebody else, we'll do it for them as well. If there are 2 advanced directives, you did a living will or a directive to physicians 2 years ago and you do one now, the latest one in time rules. And the last one that I'm going to cover here is the appointment of agent to control disposition of remains. I think we're going to be doing that also. This is that hard conversation that you have with your family about what you want done with your body, your remains, after you pass away. And it determines if you're cremated, buried, have a funeral, who's invited, whatever you can say in that. And here you can designate an agent, a second or third agent. Again, it's not in effect till you pass away, so nobody can dispose of your body while you're still alive. Don't worry about that. But again, this can be a very, very useful tool. It's kind of, on all these things, you're giving a gift to your family because they don't have to wonder about what your wishes were. What happens with your body, again, what happens with your home, who makes these hard decisions for you. It's not just for you, it's a gift to your family, so they don't have to it makes it easier on them during a tough time. That's the end of this presentation. Again, I'll stay here until all questions are done. Just letting you know, in addition to this clinic that we're assisting with, you can just contact us on our own for different things. We serve all 254 counties. We're Spanish speaking. We do pension matters. We have a veterans program. We'll do expunctions of criminal records. We get people temporary occupational driver's licenses. things like that. So that's what Texas Legal Services Centers do. But again, this is a wonderful clinic that the area agency is putting on. They're offering a lot of free things. Take advantage of it, or have the people that you care for, or your loved ones, take advantage of this and sign up for some of these products here. Any other questions of that?
Yes, we have, one person said the only thing I won't accept is blood. Which form would she have to use?
I'm sorry, the only thing I won't accept.
Is blood. She won't accept blood. So which form would she need to use?
Oh, I see. That can even be, I think there is a special provision in the medical power of attorney where you can write special instructions down. I would probably write it in there.
Do these documents apply if you're out of the country?
They apply if you're in other states, possibly. I don't know that they would apply out of country. I think the other countries would have their own set of laws. So probably not.
So if anyone would like to ask questions directly to Mr. Zambie, you can unmute yourself at this time.
And if you have a question that may be too personal, or maybe you don't want to ask it in front of the group, that is my direct line, and that's my direct email address. And you can leave a message, I'll answer it, but that doesn't go to some switchboard. That's my direct number.
Yes, Doug,
Yes, Donna.
I have a question. We have a warranty deed on the house and it's listed in our trust with our 2 children as beneficiaries. What should we do now?
Well, if you've already put it in a trust, that may solve all of your needs. I mean, a trust generally avoids probate, depending on how the trust is written, and they can be done any number of ways. It may or may not protect from Medicaid estate recovery. You literally cannot do a transfer on death deed because right now you don't own the property. Your trust owns the property. But again, the trust, I assume that you had an attorney help you with that. You probably asked him, does it do this, do that?
Yes.
And you're probably good, especially, I know probably 100% it's going to protect against probate. You can avoid that.
Right.
I'm not sure about the Medicaid estate recovery.
It's listed as a warranty deed.
Well, a warranty deed is just the most popular deed of how you transfer title to somebody else. So what you're saying is that, yeah, you're the grantor, you're giving it to this trust who's the grantee, and you're warranting that you have good title on it.
Right. So then, okay, so then we just have it to our children, but it doesn't protect us, you're saying, with Medicaid. So should we change it to the TODD?
Maybe not. I mean, you'd have to get with your attorney who drew it up. Again, because it avoids probate right there. When something goes into probate, that's when Medicaid can get it. So if it's going outside of probate, right there, the kind of assumption is that it will protect against Medicaid estate recovery. You just have to confirm with your attorney. It probably will, because it's going to pass that property outside of the probate court.
Okay, so that's what I have to check to make sure it's outside of probate.
Yeah.
Okay, thank you so much. You were wonderful. Very not easy to understand for an old lady.
You're very welcome.
Hi, Paul. This is Joe.
Yes.
Regarding disability trust, my Social Security disability is 2301, which fits underneath the Medicaid cap. However, I have a pension of $97 that puts me over the Medicaid.
Right, that's what they said.
So if I
Sorry, someone needs to mute themselves.
take my entire pension and put it in another trust, is there a downside to that?
Go in the other room.
Joe, I'm sorry, I'm having trouble hearing you. Someone else needs to mute themselves.
All right, let's try this again.
Okay,
Regarding the Miller's Trust, I've got my Social Security disability, I got my pension, and I got alimony. From what I read on the Miller's Trust, I have to either take all of my Social Security or all of my pension or all of my alimony and put it in the Miller's Trust to bring me underneath the cap of 2380, whatever it is. Can I just take my my pension, which will bring me underneath that? And
yes. So the question Joe has is that he has income from several different sources. It's not just one source. So let's say that your only source is Social Security, and let's say it's $2,500. You
Right.
can't say, oh, I want to put half of that in the Miller Trust. You have to put all of it in the Miller Trust. But if you have 3 different sources and those add up to the $2,500, you don't have to put all those sources in there. You can choose, I want these 2 sources in, this other source does not go in. So yes, Joe, you can choose which ones goes in, but once you choose one, all of that from that source has to go in.
okay, and is the Miller Trust, how do I let Medicaid know that I have a Miller's Trust and that I now qualify for custodial services for Medicaid?
Well, I mean, have you been denied in the past? Then you probably would have a caseworker, or you just open up a new case now and you tell them, hey, you know, I know you're going to do your investigation, my eligibility, just a heads up, I am over the income limit. I'm working on a Miller Trust, or I already have one in place.
Okay, how long does it take to get the Miller Trust set up?
A matter of months. I mean, it shouldn't be all that long. Again, it can be written up when you do the intake with the area agency. We do it, that might be 30 days or less, but then getting it funded and getting it set up with the bank, they would have other, you know, time limits, and I'm assuming that would just be a couple weeks for them. So I would say maybe less than 60 days you could set it up.
Because my pension is from a company I used to work for, and it's direct deposited into my bank account. So do I have to contact the owner of the pension and say, hey, you now have to do the direct deposit into the Miller Trust?
Yes, if that's the one that you're going to put in there, absolutely.
Yeah, okay. So after this call, can I contact you to get this thing started?
Well, no, you'll actually contact the area agency, and they'll have a couple intake forms.
Yeah, I filled
We
them out.
can be available for questions, but it starts there. This is their clinic.
I filled them out and I'm waiting for legal assistance to call me.
I'm sorry,
I filled out the intake forms,
oh, okay.
sent them in through Alice. And she had a question about whether or not I can be the trustee. And the answer to that is yes. If I become incapacitated, then I'd have my ex-spouse make the decisions. Is that allowable?
It is allowable, I think, for you to be the trustee. Again, as I mentioned, it may not be the best idea, but you're aware of it. And, you know, as long as you make provisions where that can be changed and you have somebody in mind.
Okay, so like I said, I've sent in the intake form, I sent
Okay.
in my pension form, I sent
Well,
Social Security. So what's the next step?
I have seen a couple come across, so I'm assuming it's just in queue and we're preparing those. So we will be giving it back to the area agency when we're done with it, and then they'll be contacting you to get it notarized or just whatever. So
Mr. Joe, Norma Baker is working on your intake at this time.
Okay, thanks, Alice.
Ms. Yvette,
Paul,
you're welcome.
you did a great job. I look forward to being able to download this and digest all the many facets that you brought to our attention. I just want to thank you for your part.
you're very welcome. Thank you.
We have another question. If you use the Todd and designate multiple recipients on your property, does it get split evenly, or do these individuals have to dispose of the property to split the proceeds?
Well, if you have, it does get split evenly depending on how many people you leave it to. So if it's 2 people, it's 50-50. You can't say 75%, 25%. If it's 5 people, split evenly, they each get 20%. Thereafter, those people can say, boy, I don't want the property, or I knew that mom wanted you to have it. And they can actually deed their 20% of their share over to one person or another person, or just whatever it is. As far as splitting and then they all own an equal share of the home. And then what they do after that, they can sell it again, keep it, rent it. I mean, but the good thing is it can't be sold unless everybody agrees. So let's say one person wants to buy it, they can have the others, for money or compensation, give them their other shares. But it is gone in equal shares to everybody.
Are there any other questions for Mr. Paul?
Okay, well then again, my information is down here, and thank you very much for attending, and take advantage of this. The area agency is doing a great thing here.
Thanks, Paul.
You're very welcome.
Awesome job as usual.
Well, I'm going to sign off now. If there's no other questions, everybody have a great day.